Melissa, can you say something? We just want to test audio real quick. Make sure.
Yes, I'm here.
Try again.
I'm here.
Thank you. We were supposed to give you a sound bar. I don't know why you don't have one.
All right. Judge, you are currently being live streamed to YouTube.
Okay.
So I will, if you guys are ready.
We're ready.
Yeah, will we see the attorneys or?
No, you'll just hear them.
Okay.
Counsels, are you all three on the call?
All right, shall we call the case?
Okay, like I said in my message, please mute unless you are speaking.
Okay, well, welcome to the brave new world. This is the matter of Desiderio-Huberdaeu versus GEICO versus Hein, Sussex L46-17, and may we have appearances, please?
Good morning, Your Honor. Robert W. McAndrew Voto on behalf of the plaintiff.
Morning, sir.
Good morning, Your Honor. This is Darren Kale on behalf of defendant GEICO.
I'm sorry, I didn't get your last name?
It's
Kale?
Kale, Judge, K-A-Y-A-L.
Okay. Right. It's a little bit.
Good morning.
Good morning. Go ahead.
I'm sorry, Judge. Good morning, Judge. This is Matthew Panis. I'm on behalf of the third-party defendants, Harleysville, Heine Heating and Plumbing, and J.H. Plumbing, Your Honor.
Okay. Well, who would like to go first?
May I, Your Honor? This is Mr. McAndrew.
Of course.
So Your Honor is faced with multiple motions here, and I want to first address the motion that I filed to reopen discovery, because I think depending on what Your Honor's ruling is on that motion, the rest of the cards kind of play themselves. So if I may it please the court and counsel, if we've learned anything in the past days, in recent days, one of the things I think we've learned is, artificial deadlines are just that, artificial. Man-imposed deadlines are just that, they're imposed. What really matters is the important things, and in this case is justice going to be done? Nothing in the rules trumps justice, fairness to the parties, and equity. No rule can be enforced if it's not just, if it's not fair, and not equitable. So in this case, Your Honor, the plaintiff is basically throwing herself on the mercy of the court to reopen discovery. And one of the points that I made, and just to put a little more flesh on it, the procedural history of this case is not good. The original complaint was filed January 23rd, 2017. Now, and likely as it may seem, not all parties who are now before the court were before the court until July 25th, 2019, when the third-party defendant's answer was filed. Now, in between, so 2.5 years, in between that, the original answer by GEICO was not finally filed and accepted by the court until December of 2018. The order granting leave to file a third-party complaint was entered in April of 2019. So, in point of fact, it's only been about 7 months since all of the parties having an interest in this litigation have been joined and are properly before the court. You have also and by the way, in the intervening time, as the court is aware from the case jacket, multiple motions, multiple deficiency notices for various filings. No motion was ever decided on the original return date. All of the motions were decided based on extensions of the return dates. As I certified in the certification that I submitted, I still don't believe I have the entire file from Mr. Marchese, because in the motion papers filed by my adversaries for dismissal based on failure to make discovery, that's when I found out what discovery was demanded and that it was never answered. I have not received the full file. I have nothing other than my client's medical records, which are extensive, and a copy of the complaint. So my client has said she was totally in the dark, Ms. Desiderio-Huberdaeu, totally in the dark as to whether there was anything whatsoever awry with her case, and that if anything had ever been asked of her, she would have immediately provided it. So my argument to the court is that this is an exceptional circumstance. It's kind of a confluence of events outside of the control of the plaintiff that have resulted in a significant period of time having passed without discovery having been exchanged, which the defendants certainly are clearly entitled to. But that discovery is readily available and can be provided, and I would submit to the court that there's no prejudice whatsoever to the defendant. And by the way, the dispute that the plaintiff has is with GEICO. It's not with the third-party defendant. The third-party defendant was brought in by GEICO, so whatever claims exist between GEICO and the third-party defendant have to stand on their own merits. And I would further submit, by the way, and I've stated it in my opposition to the third-party defendant summary judgment motion, there's no basis for the third-party defendant to move for summary judgment against the plaintiff. There are no issues of fact or in law asserted in this complaint by the plaintiff against the third-party defendant. So that portion of the third-party defendant's motion is without merit in my, as I have argued. So I have submitted as part of the motion a proposed order which would more likely than not, if granted, require a reopening of discovery for a period of somewhere between, at a minimum of 90 to 100 days to a maximum of 150 days. And I see no prejudice to the defendant GEICO. The plaintiff is ready, willing, and able to respond very promptly to whatever discovery is outstanding. We would request some very limited discovery from GEICO. The plaintiff is ready, willing, and able to appear on short notice for a deposition, assuming that depositions are still part of the world we live in the foreseeable future. And by the way, there's no prejudice to anybody, because right now things are on a more or less standstill, not just in the courts, but in the world we live in. So I respectfully submit to the court that in view of the fact that there's no prejudice, in view of the fact that the law abhors a default, and that the prejudice to the plaintiff is the most extreme prejudice that can be visited upon her, namely the loss of her cause of action, that the interests of justice, fairness, would weigh heavily in favor of the court granting the motion to reopen discovery, to set a very strict and brief but sufficient period of time to complete that discovery, so that the case can be decided on its merits and not on the basis of an absence of fact. Thank you.
Mr. McAndrew, I'm looking at your draft order. If you had your way, how would you fill in the blanks is what I'm looking at. Page 2.
Okay, sure. So the plaintiff could certainly, the first two parts, plaintiff responding to outstanding discovery and maybe getting some discovery from GEICO, it would be coincidental dates. In other words, probably 30 days.
Where are you looking?
So on page 2, within, say, 10 days, the plaintiff would serve a brief set of interrogatories and demand for documents and get answers within 20 days. So that's 30 days right there. But the plaintiff, meanwhile, would have to respond to any outstanding discovery within that same 30-day period. So far, we're only going out 30 days.
How about that?
Conducting depositions, again, assuming that the world we live in permits the conducting of depositions. And by the way, my court reporting service, and I'm sure others as well, are now providing, are capable of video deposition conferencing at no extra charge. But that would be another 30 days. So, so conduct depositions no later than May 15th, something like that. Then the experts reports probably we need another 30 days each. So as I said, probably being generous, it would be 120 or 150 days from today.
Given what you just told me, it looks like 90.
Okay, that I mean I may be
I'm
reading
just
it
trying to actually, no, you're right. You're right.
Yeah.
It is 120. Right. Sorry, my math was
Right.
off.
Yeah. So in the scheme of things, where you have a case where it took 2.5 years to get everybody before the court, I really respectfully suggest that another 5 months is not irrational for sure, and certainly I think it would be equitable.
All right. Thank you. So who wishes to speak in opposition?
Judge, this is Darren Cahill for GEICO. Since I'm the direct defendant, I guess I should go first.
Go ahead.
Thank you, Judge. I wasn't sure if anybody heard me. Judge, the facts that were laid out by Mr. McAndrew, and I understand the position he's in. He's doing the best he can for his client, and I certainly respect that. But the facts that he's laid out really are the facts for a case of legal malpractice, and that is what this case has been since the beginning of it in 2017. This is a case where plaintiff had a lawyer. That lawyer failed to file suit within the 2-year statute of limitations against the defendants that caused this accident, and then waited approximately 6 years to bring a UM claim against her own carrier, GEICO, in a case that is not a UM claim. This is an identified defendant vehicle with insurance coverage. It has been from the beginning. The plaintiff has testified under oath in municipal court proceedings that this was the vehicle that caused the accident. This was the vehicle that caused the injury. So reopening discovery is really irrelevant at this point. There's just no valid UM claim that can be brought against GEICO because of her prior testimony and her prior identification of the truck that caused the accident. And that's really been the problem all along. And there have been a lot of delays. Again, they were caused by plaintiff's prior counsel. This was not delays caused by any of the defendants, which is why I think Mr. McAndrew has a great legal malpractice case, but he's got a terrible UM case. And the problem is further aggravated here because we're now, I guess, 9 years out from the accident. It sounds crazy to say that, but that is the truth. We're 9 years out from this accident. We have no medical records in 800 days of discovery, not a single medical record, not a certification of permanency on a 2017 docket case. So, Judge, respectfully, this is not a case that deserves to be resuscitated. This is a case that should be dismissed. I think if you look at what the appellate division would do with something like this, I think it's very clear that this would be a case that they would say a dismissal is really appropriate. Mr. Marchese hopefully paid his legal malpractice premiums because that is where this case belongs.
May I respond, Your Honor?
Well, let's see if Mr. Panas has anything to say.
Sure.
Judge, just very briefly, I would echo the sentiments of counsel for GEICO. And I'd also note, Your Honor, that the moving papers to extend discovery did not attach the prior court orders in this case extending extending discovery as required by the court rules. Regardless, Judge, just for the record, there was a prior case management conference on March 8th, 2019, where plaintiff's prior counsel, Dan Marchese, was present. Mr. Kale had an attorney, John Amari, from his office that was present before Judge Weaver in court per the case management order entered by Judge Weaver on March 8th, 2019, which is over 2 years after plaintiff filed her complaint in this case, Judge. And specifically, the first thing in that case management order indicates that plaintiff was required to provide answers to interrogatories within 20 days of March 8th, 2019. That was not done, Your Honor. Eventually, a third-party complaint was filed against Harleysville Insurance Company, as well as both Heine defendants in this case. The Heine defendants have been dismissed for lack of prosecution, but service was effectuated on Harleysville. My office filed an answer on behalf of Harleysville and immediately filed a motion to extend discovery based upon the fact that there was no answers to interrogatories supplied by plaintiff in this case. So on August 16th, 2019, Judge Weaver entered an order extending discovery in this case, and plaintiff was required once again to provide written discovery responses by September 1st of the year 2019. That was not done. On the bottom of Judge Weaver's order, Judge Weaver handwrote a couple sentences, and he specifically noted his last full sentence. He underlined the word all, and he said, all parties must make this case a priority and abide by discovery deadline, or there will be appropriate sanctions, period. Future extensions are, and he underlined, highly unlikely. Judge, based upon all of the papers in this case, based upon the arguments made by Mr. Kale here today, as well as myself, there are not exceptional circumstances whatsoever to extend discovery in this case. There's no reason whatsoever that written discovery responses were never provided by plaintiff via her prior counsel per Judge Weaver's 2 prior court orders. The court rules also require Form A answers to interrogatories are mandatorily required to be provided within 30 days of a defendant, GEICO, filing its answer in this case. That was never done. Not a single document has been provided in over 800 days by plaintiff to support any claim for damages, and it's not exceptional circumstances for the cases we cited in our most recent papers to the court, Judge.
Thank you. Mr. McAndrews.
Thank you, Your Honor. Your Honor, let me first address Mr. Kale's argument about this isn't a UM claim. So in opposition to one of the motions filed by his office, I think it was the one that he signed, I spelled out to the court that although the plaintiff believed that Mr. Heine or his company's vehicle was involved in the accident and he was convicted in municipal court, that conviction was overturned on appeal because the state had failed to turn over a video which had been a dash cam video by one of the responding officers, which in effect vindicated him. It contained exculpatory video, and in fact, in any event, I attached information regarding that to my opposition. So if GEICO thinks they can prove that it was Mr. Heine, that's fine. But right now, under the law, the client, the plaintiff, the insured, does have a viable uninsured motorist claim. Now, to respect to what Mr. Panis said, I can't dispute the fact that Judge Weaver entered orders, and I can't dispute what they said. Those are facts. The unfortunate situation is the plaintiff had no idea any of this was going on. So how can you say that's not an exceptional circumstance? Because if it wasn't, we'd have motions like this all the time. It's not expected that an attorney will not keep the client informed. It's not expected that the discovery will not be provided. If a plaintiff willfully neglects to provide discovery or willfully refuses to provide discovery, different story. Then the plaintiff has to pay the price. With regard to a suggestion by Mr. Kale that, oh, this is a good legal malpractice case, well, the plaintiff is suing Mr. Marchese for malpractice. However, I fear that he does not have insurance because it's been 45 days roughly since he was personally served with the summons and complaint in that case, and there has been no response from any insurance company, any attorney, or Mr. Marchese himself. So my fear is that, you know, as good as the case might be based on liability, there may be no insurance involved on his behalf. So that's neither here nor there. It's not really part of what Your Honor has to decide. But since Mr. Kale elected to bring it up, I think it was important that the court know what is going on in that regard. So, again, my basic argument to the court is nothing supersedes the interests of justice. The law abhors the default. When possible and when there's no prejudice, and I haven't heard anything on that score by the defendants, the court should use its discretion to favor the innocent party.
I learned a while ago, and I think you can confirm this, that a sole practitioner need not carry malpractice insurance. I was amazed to find that out, but I think that's so.
Well, that's the actual rule, Your Honor, is that if you are practicing solely in your own name, that is true. But if you practice in any kind of corporate form, an LLC, an LLP, a PA, you are required by rule to carry insurance, and the rules do specify the limits that you must carry.
Was he operating under an LLC?
No. Yes. He's operating under in a corporate form.
So he's obligated therefore to have insurance. Okay, but you're right.
The only question is whether he reported it in time.
Well, it's probably not a factor that I should consider in any event.
It is not. It is not.
Okay. Gentlemen, anything else?
Your Honor, very briefly, this is Matthew Panis again on behalf of the third-party defendants. As we noted, Your Honor, in our reply brief, and Mr. Kale noted in his opposition, we both cited the O'Donnell versus Ahmed case 363, NJ Super 44, pages 51 to 52, Law Division 2003, defining extraordinary circumstances as legitimate problems beyond mere attorney negligence, inadvertence, or the pressure of a busy schedule, Your Honor. And then also in regards to prejudice, Judge, as talked about by Mr. Kale, the accident occurred 9 years ago, Your Honor. The retention of medical records, including those for MRI films and diagnostic studies, CT scans, x-rays, only go back 7 years, Your Honor. So there's without a doubt prejudice in that regard, including if the plaintiff had prior accidents, maybe those records are no longer in existence. And also, very importantly, Judge, in this case, memory's lost. There's numerous police officers that responded to this incident. It's a claim that ICE came off a box truck over 9 years ago. There were various officers with dash cam videos that responded to the accident, to responded to various other places. And based upon the age of the case, the unique factors with multiple witnesses in this case, Judge, and memories fading, the defendants are severely prejudiced in this case. Since our position, quite frankly, there's no extraordinary or exceptional circumstances to extend discovery. Thank you, Judge.
No problem. Anybody else?
Your Honor, one more word. First of all, I still am objecting, as it were, for Mr. Panis to make any argument that the complaint should be dismissed because we have no claim against him. That's number one. But number two, the plaintiff operates under the same burden regarding medical records, and it's not unusual in cases where it's a prior injury, where someone had an injury 10 years ago and claims aggravation of that injury in an accident that happened yesterday. So if there is a problem of getting proofs, the plaintiff has the burden of proof, so the plaintiff would be the one who may suffer based on length of time, not the defendants, because the plaintiff has the burden of proof. So if there's a failure to meet that burden, then the plaintiff's case will fail.
All right, anything else? All right, this is a difficult, I guess the position of this case is a difficult one for the court to consider because, as you know, I handled the previous motions, including the one removing Mr. Marchese. He had the case for many years. It's got a very strange history. The bottom line is I'm going to grant the application to extend discovery really for two reasons. I agree with Mr. McAndrews that the law disfavors defaults. And we have new counsel here, Mr. McAndrews. I know him well as a professional. I know that he will move this case to the best of his ability. And what he's asking for really is an extension of discovery up until, let's say, September 1. Right now, as you know, there's no jury trials going on anywhere in the state, as far as I know. We are in an extraordinary situation. Things have been delayed because of the pandemic, I guess it is. And I think, but that's not really the main factor. The main factor is I think the plaintiff has a right to ordain court. Taking the position that, yes, okay, but she's got a great malpractice case, so let it go that way, is not a satisfactory outcome to me. I think she should have her day in court. I will therefore extend discovery. I'll fill in the dates. But based on what I heard before, I think we're looking at somewhere around September 1 as a discovery end date. I'll put the dates in the order, but I'm going to grant the application. I do so somewhat reluctantly because I understand the history of this. But I think in fairness, I think she should be given an opportunity to proceed. Now, the argument was also made that this isn't even a UM claim. Well, it's not appropriate at this point to dismiss it because it's not a UM claim, although we'll get to that motion in a bit. But the point is that there is a dispute, material dispute as to fact as to whether the Mr. Hine, I guess it is, or Hine Plumbing, was the defendant. It's clear she testified he was, but on the other hand, the criminal record shows that he wasn't. So there is a material issue of fact right now, at least. So bottom line, I will reopen discovery and put a new discovery end date of September 1. I'll fill in the rest of the dates. So, okay, gentlemen, we're ready for you. I think there's other motions. I'm happy to hear them.
There are, Judge. So, Judge, this is Matthew Panis on behalf of third-party defendant Harleysville, Judge. And Judge, we filed a summary judgment on two grounds in this case. First, Harleysville filed summary judgment that GEICO has no standing whatsoever to sue it. It's my understanding that that motion is unopposed, Judge. So, for the reasons stated in our moving papers in regards to that respect of the motion, it should be granted.
Right. There was another.
Judge,
I think you asked that it be dismissed as to the plaintiff also.
Judge, I did in regards to the verbal threshold. Now that the fact that your Honor's extending discovery in this case, I'm not sure if that affects the outcome. I mean, listen, it's our position that we are entitled to summary judgment on the verbal threshold. GEICO would also be entitled to summary judgment regarding same. As a result, the third party complaint then goes away as to my client's. Plaintiff is subject to the verbal threshold, must prove an injury based upon objective, credible medical evidence based upon a doctor, and has never done so. As a result,
Yeah, but you're not a defendant from the plaintiff. Plaintiff didn't file suit. So how do you have standing to bring the motion as to the plaintiff?
Judge, that's fine. I'll rely upon Mr. Kale's arguments then in that regard, because he has the same motion pending against the plaintiff, Judge. But in regards to the motion at the Harleysville as the UM standing, it's unopposed. They have no standing to sue Harleysville, GEICO in this case.
Thank you. That I understand. Anybody else on that motion?
Just in response, I think given the fact that discovery is now reopened, I would like Harleysville to remain in the case only for the purposes of conducting the depositions of their insured to find out if he was driving the truck that day. I certainly understand the arguments about the municipal court proceedings, but frankly, that is not dispositive on whether or not the truck involved was his truck or not.
It is not.
Whether or not he was convicted. Yeah.
I
So I think only for that for the time period. If Mr. Panis at the end of discovery refiles his application, I won't oppose it then either. If we're going to establish these facts, I think it's important to have him involved just so we have a body who can produce somebody for me for a deposition.
Mr. Panis?
Yeah, Judge, just briefly, I mean, there's no case law rule or anything to support that proposition that you can sue an insurance carrier as a direct defendant or a third-party defendant to ensure that their insured appears at deposition. There's no support for that whatsoever, and the Heineys are third-party defendants in this case, Judge. Their third-party complaint has been dismissed for lack of prosecution for many, many months. In this case, GEICO eventually would need to serve them and try to file a motion to vacate the dismissal for lack of prosecution by showing exceptional circumstances. But Harleysville is entitled to summary judgment at this point in time. There's nothing to support keeping them in the case as a third-party defendant, Your Honor, respectfully.
Anything else? All right, I'm inclined to agree with you, and I therefore will grant the application to dismiss. Okay, let's.
Thank you, Judge.
Thank you. Okay, we've got another motion, I think, right?
Well, Mr. Kyle's office has two motions, actually.
Right. So, sir,
Judge, I think your ruling on reopening discovery renders the in regards to both the UM claim and the verbal threshold motion obviously are now, I guess, premature. So I can't think of anything I could argue other than saying that, obviously we're 3 years out and there's still been no certification of permanency filed, which is a requirement to be filed within 60 days of filing a complaint. So I think statutorily the case can be dismissed just on that basis alone. But certainly given the fact that discovery is reopened, I'll defer to the court on that.
Okay, well, as you just indicated, I do deem these as premature and will deny the applications. Okay, anything else, gentlemen?
I would just like to thank Mr. Kyle for being forthright and in addressing his motions.
I appreciate that also. All right, let me make this offer too. This case has to move in accordance with the schedule. And I know Judge Weaver sounded tough in his orders, and I'm not going to threaten anybody, but what I'm going to do is offer to have a case management conference at any time any of you feel that this case is not moving in accordance with this order. I'm happy to do that. All you have to do is write me a letter. We'll set up a call and talk about moving things along in order so that this case is really ready to try in the fall. Okay, I'm happy to do that.
Thank you, Your Honor.
Anything else, gentlemen? Okay, we'll sign orders today and put them in courts.
Thank you, Your Honor.
Thank you for cooperating with our new technology here.
You're welcome.